Hey guys, this is Hong and I'll be presenting the case 14-4, First State Bank of Sinai vs. Highland. The main topic of this case is contractual capacities of intoxicated or incompetent persons. Now let's jump into the background. Randy Highland is unable to pay promissory notes due on September 19th, 1981, and he negotiated with the First State Bank of Sinai for an extension. The bank agreed on the condition that Randy's father, Mervyn, act as a co-signer, responsible for the new promissory note that the bank drafted with the due date on April 20th, 1982. Mervyn agreed on that and signed the new notes. On the due date, the new note was unpaid, and Randy brought bank a check signed by Mervyn to cover the interest owed on the unpaid note, and asked for another extension. The bank agreed to the second extension, again on the condition that Mervyn act as a co-signer. However, Mervyn refused to sign the last note, and Randy subsequently declared bankruptcy. The bank sued Mervyn on December 19th. Here are some of the facts about this case. So Mervyn stated that he was not liable since he had been drinking heavily at the time he signed the note. And in fact, he had been involuntarily committed to an alcoholism treatment throughout this period. However, Mervyn had executed and paid his own promissory note with the bank. The trial court held that Mervyn's contract as a co-signer was void due to alcohol-related incapacity. Now let's go through some of the legal bases used in this case. So there are three types of situations for the contract liability of incompetent and intoxicated person. The first type is the person under guardianship. If a person is under guardianship by the court order, his contracts are void and no legal effect. The second is the mental illness or defect. So if a person is mentally incompetent, he may void liability under the agreement. The incompetent here means that the person is unable to understand the nature and effect of his act in entering a contract. Also, there is another type of mental incompetence recognized by the restatement of contract, is that the person understands what he's doing but cannot control his behavior in order to act in a reasonable way. The third is the intoxicated person. If a person is intoxicated and he is unable either to understand the nature and the consequences of his actions or to act in a reasonable manner, he may void the contract, although they may ratify it when the intoxicated person regains his capacities. After we get to know the legal basis, let's look into the case analysis. So in our case, Mervyn is intoxicated and mental incompetent during the time of this event, so the contract is supposed to be voidable. However, we need to notice that the void contract concept has to be applied based on the judicial determinations of incapacities. But in our case, Mervyn was not judicially declared incompetent during the note signing. In addition to that, a voidable contract may also be ratified by the party who had contracted while disabled. Upon ratifications, the contract becomes a fully valid legal obligation. So if Mervyn wished to avoid the contract, he should exercise the right of rescission instead of paying the interest with the signed check. In conclusion, even though Mervyn's obligations on the note was voidable, his subsequent failures on lack of rescission and his ratification transformed the voidable contract into one that is fully binding upon him. So we conclude that Mervyn's obligations to the bank is not void. Thank you so much.